Welcome back to my mock trial series. Today I'm going to take a look at relevancy objections. So one of the objections that you can make during a court case or any sort of a hearing is relevancy. People don't get to say anything that they want to say during a trial. The court limits individuals to things that are relevant, which means that it has a bearing on the issue at hand. Things that are not relevant, that are irrelevant, shouldn't come into court. Now, here's the thing that I'm going to tell you about this right away. Every day across the United States of America, there are hundreds, if not thousands, of irrelevant questions asked in court hearings, and hundreds, if not thousands, of irrelevant responses given. Why is that, given what I just said? The answer is, by and large, you're not going to object to every single question that may or may not be relevant. You don't do that for strategic purposes. You don't want to look obstructionist when things aren't going to make a difference. Ergo, we typically only object in a courtroom when something is irrelevant and prejudicial. The and prejudicial part is very important in this case. Answers that are irrelevant but don't really hurt our case aren't usually worth objecting to because they're not going to matter anyway, and you don't want to look obstructionist. On the other hand, if the opposing attorney asks a question which is going to elicit a response which is likely going to be harmful to your case or your client, then you want to make sure to lodge an objection on relevancy grounds right away. Let's walk through two examples. In the first example, we're going to pretend that we're doing a run-of-the-mill theft case. Theft has three elements. Number one, that the defendant takes and carries something away. Number two, that said item had some value to it. And number three, they didn't consent to take said item. So given that those are the elements of the offense and only things that have bearings on those three elements are relevant, let's take a look at a couple of questions. Let's imagine that the question was, did you pay for the item before removing it from the store? Our options in this case, should we A, make no objection because the question is relevant, B, make no objection, the question isn't relevant, but it's not prejudicial, or C, we should object. The question is both irrelevant and likely to elicit prejudicial information. I'll pause for a second. The answer in this case is A. We would not object to this question. This question is relevant. Whether or not the person paid for the item has a bearing on consent to remove that item, and therefore is directly relevant to the case. Let's consider the next question. Question: what did you do after you left the store? Pretending we're talking to the defendant in this case. I'll pause for a moment, select what you think is the correct answer. In this case, I would say that the correct answer is B. I wouldn't object. Does it have any bearing on whether or not the person took or carried away the item? No. Does it have any bearing on whether or not the item is of value? No. Does it have any bearing as to whether or not the person consented to having the item taken away? No. So it's not relevant because what someone did after the crime in question is not relevant. But it also doesn't really matter. Frankly, what the person does after they left has no real bearing one way or the other on the outcome of the case. So unless you have special individual knowledge that this is going to elicit a negative response for your side, I'd let it go. Last one for this example. Question: why did you take the item without paying for it? Choose your answer. In this case, we would lodge an objection. C. This question is not relevant because the state of mind of the individual has nothing to do with the offense in this case, because it's what's called a strict liability offense, which means what they were thinking is irrelevant. The other reason that I would object is it could elicit a response, especially for some people, that might make the defendant sympathetic. Let's say that they had a really compelling reason why they had to take the item. The usual is, I needed to steal this bread to save my starving children, right? Is that relevant to whether or not you had consent to take it? No. But is it prejudicial? Potentially, because there are potentially people on the jury in this case who may feel sympathy with the defendant in that situation. So this is a case that you'd want to lodge an objection. Let's take a look at another example. In this example, we're just going to do a run-of-the-mill car accident. Somebody allegedly turned when the light was red. They didn't have the right of way. They should have yielded the space. They didn't, and it caused an accident. So those are the allegations. This is a case where negligence is the standard. Negligence is when somebody fails to behave with what we would say is ordinary prudence or ordinary standard of care, right? So we all expect in all of our given lives that people will take a reasonable sense of care, sense of level of care, all right? So people are going to do reasonable things to keep us all safe. Example in a car is we all assume people are not going to be using their cellular phones in such a way that makes it so that they cannot see the road. If you do that and then you cause an automobile accident, you were negligent. You didn't intend it to happen, but you were negligent. So let's look at a couple of questions. First question: where were you on the date in question? Same three options, A, B, and C. Which would you choose? I'll give you a second. In this case, it's A. No objection. The question is relevant. We need to know where the person was at the date in question. And that's an important point that I wanted to bring up. There are questions which are what we call foundational, which means we can't get to the accident until we know that this person was on the scene during the accident. So just because it doesn't have a direct bearing on the question of negligence right away, that doesn't mean that it won't down the road. So this question would be a relevant question because we need to know who was at the accident. Next question: what did the other driver tell you after the accident? Take your choice. This one I would definitely say is C. This is an objectionable question. I would object to this question. First of all, it's hearsay, and you can watch the video on hearsay to understand that a little bit more. But the more important reason is if the other driver said something like, I'm sorry, or it was my fault, or so on and so forth, when it really wasn't, because they didn't know what they were talking about, or maybe they were overcome with emotion, you don't want that information coming into trial. The question was whether or not the person needed to yield, whether or not the light was red. It's not whether or not somebody said sorry. So it's not particularly relevant in this case, and it could be very prejudicial to your client. Next one. What color was the car that struck you? Take your pick. In this case, I think that's probably B. I wouldn't object. The question isn't particularly relevant. It doesn't really matter unless for some weird reason we can't identify the car, but in this case, we assume we can. Still, I wouldn't object. The question isn't relevant, but it in no way prejudices the jury or the finder of fact against our position, because who really cares what color the car was? Last one. When did you last have your vehicle serviced? Take your pick. I would go with C on this one. I would object. And the reason is, again, it doesn't have anything to do with the case at hand. Whether or not the light was red has nothing to do with whether or not you recently had an oil change in your vehicle. At the same time, the jury might be prejudiced to discover that perhaps one of the motorists hasn't done the best job of keeping their vehicle up to date. That could be problematic for you going forward. And so you want to make sure that you keep that piece of irrelevant information from coming out. Okay, so relevancy. Relevancy, in the end, is an objection that gets lodged fairly frequently, but it's also an objection that's very strategic in nature. And therefore, it's something that takes a lot of practice. If you are working with a mock trial team, I highly encourage you to practice working on relevancy objections, both as the attorney and as the witness, so that you understand how different facts connect and how relevancy can work in a courtroom setting.